Welcome to good evening and welcome to this evening's program, In Whose Interest When ICE Partners with Local Law Enforcement. Please note that this webinar is being recorded. I'm Alan Willinger, Advocacy Director of the League of Women Voters of Greater Pittsburgh, and my co-host is Kathy Schubel, Program Director of the League of Women Voters of Greater Pittsburgh. For those who may not be familiar with the League of Women Voters, we are a nonpartisan political organization that neither supports nor opposes any candidate or political party. So in this webinar, partisan questions won't be answered. We have 300 plus members based here in Pittsburgh, and we work hard to see that every vote counts. We help citizens register to vote, hold candidate forums, distribute information to senior citizens, incarcerated people, and newly naturalized citizens, present civic education programs in schools. We show citizens how to spot misinformation and disinformation. We publish an annual guide to local government officials, and we engage in advocacy, such as this evening's program. Today, we will hear about the problems with towns cooperating with the federal government in enforcement of immigration laws. To give you a little background, in 2025, about 540,000 people were deported from the United States, according to the New York Times. About 230,000 of those were arrested from the interior of the country, and this number is higher than the total during the entire 4 years of the previous administration. As of January 15th, about 70,000 people are in detention, an 84% increase from 1 year ago. Within a 50-mile radius from downtown Pittsburgh, there were 948 immigration-related arrests from January 20th to mid-October last year, more than triple the same period in 2024. During the same time period, at least 810 people were detained at the ICE facility in the south side of Pittsburgh. Only 1 in 5 had a criminal conviction. The current administration's deportation program is cruel, often illegal, and deadly. It is cruel. Most people detained or deported are playing by the rules, contributing to their communities, not committing crimes. People in detention are often mistreated, sometimes dying. Families live in fear just walking to a store, and some have been ripped apart. A local immigrant advocacy group, Casa San Jose, had to go virtual to protect its clients. The current administration's deportation program is often illegal. Last year, the current administration declared that undocumented immigrants apprehended in the country's interior were not eligible for bond while in detention. More than 300 district court judges have ruled that policy violates federal law. Also, the chief U.S. District Court judge in Minnesota said in an order that ICE violated 96 court orders. The current administration's deportation program is sometimes deadly. We've all heard about the killings by ICE and Customs and Border Protection of U.S. citizens Renee Nicole Good, and Alex Preddy. ICE and CBP are out of control. Why would any town want to cooperate with them? The goal of tonight's program is to give you the information and resources you need to urge your town council to rescind a 287G agreement if it has one, and to urge your town council to pass a resolution to not cooperate with ICE and CBP. I will send out a follow-up email to everyone here tonight after this webinar. The email will be blind carbon copy. During the presentations tonight, you can type questions using the Q&A function. Polly will monitor the questions and ask them during each presentation. We request that you be respectful when asking questions. We are fortunate to have two distinguished speakers tonight. The first is Keith Armstrong. Keith is a fellowship attorney for immigrant rights at the ACLU of Pennsylvania, based out of the Philadelphia office. He joined the ACLU PA in October 2023, where he has litigated a varied docket of cases in federal and state courts, including a challenge to President Trump's invocation of the Alien Enemies Act, habeas cases challenging unlawful immigration detention, government transparency cases, and relevant to this presentation, Make the Road Pennsylvania versus Harron, which argues that the Bucks County Sheriff lacked the legal authority to enter in a 287G agreement with ICE. Prior to joining the ACLU PA, he worked on the federal litigation team at RACES, a Texas-based immigrants' rights coalition. Keith graduated from Northwestern Pritzker School of Law with a JD and an LLM in International Human Rights, and holds a BA in English and International Studies from College, Macalester College. The second speaker tonight is Amy Weidstrom. Amy holds a BA in English and Theater from Oberlin College and both an MA and PhD in Political Science from Syracuse University. Her academic expertise lies in American politics with a focus on civic engagement, public policy, campaigns and elections, and the role of women in politics. Prior to joining the League, Amy served as a faculty member and chair of the Department of Historical and Political Studies at Arcadia University. Her professional background also includes roles in the nonprofit sector at the Brookings Institution and with the United States Senate Committee on Banking, Housing, and Urban Affairs. And Amy is our executive director of the League of Women Voters of Pennsylvania. So I'd like to turn this over briefly to Amy to introduce the topic.
Thank you, Alan, and thank you to the League of Greater Pittsburgh for having me, and Keith, thank you for joining us. This is a really timely topic, and so I'm pleased that we have a good crowd, it seems. One quick housekeeping: if anybody needs closed captioning, you can go to the three little dots on the bottom of your screen. I think it's under settings and then accessibility. And so you can turn closed captioning on your side of this presentation. And as Alan said, you can ask questions in the chat. All right. Next slide, please, Polly. All right. So as Alan noted, the purpose of tonight's program is to learn about the risks of local cooperation with federal immigration enforcement through these 287G agreements, and to gain tools and resources to urge your town council to rescind existing agreements and or adopt policies declining cooperation with these entities. Now, I want to note something that the League of Women Voters often gets as a question. As a nonpartisan organization, it's important to know that we do not work with parties, we do not work with candidates, we do not endorse candidates. The League does, however, take positions that advance voting rights, voting access, and civil rights. And so that can be a little tricky, I think, for some folks to hear a nonpartisan organization take a position such as this one. And when issues or current events run counter to the core mission of a nonpartisan organization, taking a position on an issue doesn't violate that nonpartisanship, right? Because we are not we are equally critical of everybody who is not advancing our mission and our goals. So our goal tonight is to bring Keith's expertise to bear. We're going to talk about what a 287G agreement is, what the nature of these relationships are between ICE and state and local governments. What are the problems with these agreements? What are some of the current legal challenges? And then we'll talk about really jurisdiction and separation of powers and how these agreements actually challenge jurisdictional authority and separation of powers at the local level. And then we'll talk about what can be done at the local level if these agreements are emerging in your community. Along the way, as Alan said, please use the Q&A to ask questions. We'll sort of stop at natural breaks to answer those questions, and then there will be time for questions at the end. All right, I'm going to pass it over to Keith and we can go to the next slide.
Great. Yeah, thank you, Amy, for setting the stage. Before I begin my part of this presentation, I want to just lay out clearly that nothing that I say is meant to be legal advice. I am a lawyer, but I'm not the lawyer of any of you in particular. And so while there is going to be some discussion of legal analysis and various litigation that the ACLU of Pennsylvania has undertaken, none of this is meant to, be guidance for you to take any particular course of action legally. Um, so I want to start by going into 287G agreements and giving a bit of a definition, but I think it's important first to sort of situate them within the broader set of ways that state law enforcement and state agencies can collaborate with ICE and with CBP. I'm going to probably just say ICE as shorthand, but when I say it, I mean both ICE and CBP, or federal immigration enforcement. Um, the There are sort of three key buckets of local and county law enforcement with ICE and CBP. The first one is ICE detainers, and so that happens when a local law enforcement agency holds a person in custody longer than they would have already been, or past the time they would normally be released, to transfer them to ICE custody because ICE suspects the person is removable from the United States. We also see in Pennsylvania, as a second form of collaboration, counties and local jails and other facilities leasing property or entering into intergovernmental agreements with ICE to operate ICE detention facilities. And then finally, most relevant to tonight, 287G agreements, which essentially are agreements between ICE and local law enforcement agencies, in which the local agency is deputized to enforce certain aspects of immigration law. Now, all of these entanglements between ICE and local law enforcement can be contested and can be addressed through policy and resolutions at the local level. We're focusing on 287Gs as sort of one example of this. But as we'll get to discussing, welcoming policies can and should address all of these different areas. Um, so we're not just trying to limit this arbitrarily to 287Gs. I want to just acknowledge that they fall within a broader set of ways that entanglement can happen. So a 287G agreement, like I said, is named after Section 287G of the Immigration and Nationality Act, and it deputizes a local law enforcement agency to take on aspects of federal immigration law. And so basically what it means is that these agreements delegate federal authority to local law enforcement agencies. And it means that like local law enforcement agents can perform some of the functions of ICE agents. And that can mean identifying, arresting, and detaining people for deportation and removal from the United States. I'm not going to get into all of the text here, but there are three different models of 287G agreements that exist. The most expansive, and the one that the ACLU of Pennsylvania has engaged in most of our legal challenges to, is the task force model. And it's important to acknowledge like the vast sweeping powers that this actually does grant to local law enforcement agencies. It means that local law enforcement agents can conduct warrantless arrests if they suspect that a person has entered the U.S. irregularly, and also conduct warrantless arrests if there's a reason to believe that the person is in the United States without authorization and is likely to escape without a warrant. Um, the other models are also problematic. There's the jail enforcement model and the warrant service officer model. Both of these are more about, local law enforcement and local correctional facility officers' authority over people who are already in their custody. So while harmful and while they do constitute part of the, local law enforcement to deportation pipeline, they're a little bit more limited in scope. Um, Now, some states have passed laws that restrict or ban law enforcement agencies from entering into 287G agreements, including several of our neighbor states, New Jersey, Delaware, and most recently Maryland, all have passed anti-287G legislation at the state level. Um, and on the exact flip side of that, other states, including Georgia and Florida, have actually passed legislation that requires law enforcement agencies to try to enter into 287G agreements. Pennsylvania is sort of in the middle. We don't have a state statute that goes either way. So essentially, it means that the decision at this point is up to the discretion of the local government authority. But that doesn't mean it's limitless. Let's go to the next slide. So I want to talk a little bit about the history of 287G agreements because I think it really is useful for understanding where we are right now. So one of the last major changes to the Immigration and Nationality Act, which is the big broader statute that governs pretty much all of immigration law, as well as a number of other different areas of law. The last changes to it that were very significant happened in 1996. And with those changes in 1996, which were part of the IRIRA, which is a long acronym that, but it basically like led to a lot of increased scrutiny of different criminal consequences that can lead to immigration enforcements or lead to immigration enforcement against an individual. This legislation essentially created the model for 287G agreements, but that part of the statute authorizing 287G agreements was mostly dormant for the first 6 years of since it became part of our federal law. But then after September 11th, we started to, with the establishment of the Department of Homeland Security, we started to see these 287G agreements increase more. Now, I mean, it's important to note that both the Department of Homeland Security and ICE did not exist prior to September 11th, 2001. They were part of this country's, war on terror, and they were created sort of at a time when there's a lot of conflation of immigration with terrorism and national security. And I think we're sort of back in an environment like that as well at this point. Um, so the program grew very slowly, though, in the post 9/11 era, and started to gain notice most prominently with the actions of local sheriffs like Sheriff Joe Arpaio from Maricopa County, Arizona, and then other sheriffs who really abused their powers under 287G and engaged in pretty lawless actions and widespread racial profiling. And so after the Department of Justice investigated some of these sheriffs, the program was scaled back during the Obama era. Um, and then uh, under the first Trump administration, there was a renewed interest in 287G agreements and a lot of pressure coming from his administration to encourage and incentivize law enforcement agencies across the country to enter into 287Gs. Um, the program again was scaled back under the Biden administration. Biden had campaigned on ending all 287G agreements, but ultimately the reality was that it was more of an era of non-expansion of 287Gs rather than canceling 287Gs. And so most of the agreements that were in place remained in place, but there was not an expansion. Um, Things have really changed since January 20th of last year. There's been a very aggressive push for uh, an increase in 287G agreements. As of the earlier this week, 2 days ago, I checked the numbers, and there are 1,415 agreements in place nationwide, with a few more pending. And so this is a massive escalation. And really, I mean, basically 287G agreements are at their highest level. We can go to the next slide. And it's important to look at Pennsylvania as one example of how this expansion has happened. Like I said, on January 20th of 2025, there were zero 287G agreements in Pennsylvania, but in the past 13 months at this point, there are now 60 local law enforcement agencies across Pennsylvania, or local and county, that have entered into 287G agreements, and there's one more that is pending. We've included a map there that I believe corresponds more or less to that 60, but it sort of shows the geography of where these 287G agreements are clustered. Um, Importantly for all of you in Allegheny County, since I know this is the League of Women Voters of the Greater Pittsburgh area, there are a number of law enforcement agencies in Allegheny County itself that have entered into 287G agreements. And so I've listed them here. And then even more dramatic in the counties surrounding Allegheny County. There are even more, and so each of these 287G agreements mean that there's a potential for local law enforcement in these areas, which, maybe your boroughs or townships that you're living in, where local police or sheriffs could be acting as immigration agents. Um, so yeah, I'm including this for your awareness. These are definitely some places where, I think action and advocacy could be helpful, but equally important is preventing the further spread of these in areas where they don't yet have 287G agreements, but might be on the fence about them. Let's move to the next slide.
Keith, we do have a couple questions in the Q&A. I don't know if you want to address those now or we can keep going and you can address them in a bit.
Yeah, so I'll start with the second question there about the current number is at 1445 to 1455. What's the goal number? Um, So I don't really know what the Trump administration's goal number for 287G agreements is, but they would like to, I think, have a maximum number, as many as possible. Obviously, they can't have 287G agreements in the states that have prohibited them, but I think they'd like to see them pretty much anywhere else that they could. I mean, they've been very serious about trying to expand the immigration dragnet across the United States, and this is one of the key tools in the toolbox. Essentially, like we've seen a really massive increase in hiring of ICE agents and CBP agents. But if you look at just raw numbers, there are tens of thousands of federal immigration agents, but there are even more people in local police departments and local sheriff's departments who theoretically, through these agreements, could be deputized, and that really highlights the harm of these. Um, and so, I mean, yeah, I don't know that there's any one number, but I think maximum coverage would be what the current administration's goal is. Um, and I see Let's see. So one of these questions is a little bit long. So in my town, after a contentious public meeting to discuss passing a resolution that the town will not sign any agreements with federal immigration agencies, a town council member voiced opposition to the resolution to not sign a 287G agreement because he feared that his vote for such a resolution would violate the oath he took to uphold the U.S. and Pennsylvania constitutions. Do the Pennsylvania and U.S. constitutions have any bearing on the ability of municipal councils to make a resolution not to sign an agreement? So, yeah, that's a really great question. Um, Under the US Constitution and US laws, immigration is considered to be a purely federal function. Um, the federal government has the full authority over regulating immigration. There's really very little that's left to the states in that. But at the same point, but I guess on the flip side, under the 10th Amendment, any the federal government can't coerce states to take certain actions either. And so this is called the anti-commandeering doctrine. So it means that the federal government can't force state governments or local agencies, local governments to undertake any federal actions if they don't want to voluntarily. And so that means essentially that you know, sure, there may be some wiggle room where local agencies do want to cooperate with ICE, and they can do so voluntarily, but they can't be forced to do so. So there isn't necessarily, a requirement that they cooperate or not. The law is very clear that, that there is no obligation of local law enforcement agencies to undertake federal immigration enforcement actions.
And I guess, Keith, on the flip side, the other question is, would barring collaboration or partnership with ICE or a federal agency violate the Constitution by devolving immigration to the state level when it is typically considered a federal issue? Does that make sense? Are you violating the federal nature of immigration as an issue by trying to control it and engage in these partnerships,
Yeah, so
or bar them? Right, either way.
yeah, I mean, I would say no. It's just there's no obligation on the local governments to take any action or not take any action on immigration. And so, they can, and there have been multiple decisions across the country that sort of have examined federal challenges to local legislation about various parts of non-cooperation with ICE. And so, I mean, even, in the Third Circuit, there was a case about whether the federal government could condition funding to local law enforcement agencies based on their decisions not to cooperate with ICE. And the Third Circuit Court of Appeals upheld that the local agencies can make their own decisions about this, and federal funding can't be conditioned. So I think the law, at least for now, is fairly settled. The law is dynamic and constantly changes, but I don't think there's any constitutional problem with, you know, local legislation that opts out. Opting out is always an option. Yeah, does that answer the question?
Yeah. Let's go to the next slide, and we can. We're at closer to the end of the presentation. We're going to get to some challenges to these various agreements and perhaps strategies or tactics. And so, Keith, I'll let you look at the next question, and we'll start moving on. So, one thing I think is important to note, right? There's the legality, or there are these legal questions that we have about constitutionality. For example. But then there's also the sort of politics of it all, right? The optics of it and the rhetoric. And so one thing I try to do as a political scientist and as a consumer of the news is sort of try to say, what is the flip argument, right? Like, what would be the benefit or what is the argument that somebody who supports this would give us for wanting to engage in these agreements? And first and foremost, the argument tends to rest on safety, right? That there might be a capacity issue at the local level, not enough local law enforcement to sort of address an immigration issue. Or a crime based argument that there's some criminality happening with folks who are perceived to who have come into the country irregularly. And what I want to highlight here is that the research indicates that those sorts of arguments don't hold any water, right? That this model of law enforcement of immigration at the local level does not reduce crime and may increase violent crime in some cases, actually. So we've got a study in 2018 and 2020 that argues that there's no statistically significant reduction of crime following the adoption of these agreements, and in fact actually increases assaults against law enforcement officers in the counties that have these agreements. So not only does it not reduce the crime, it actually increases crime against law enforcement officers. These agreements did not reduce violent victimization generally, and instead there was an increasing likelihood that Latinos experienced violent victimization. So they seem to both hurt our law enforcement folks and hurt marginalized communities or targeted communities. And then the specific model of law enforcement has also been addressed, although, as Keith said earlier, the task force model seems to be the most prominent. But one of the questions that also comes up is just sort of oversight and data reporting, right? What kind of data is required to be submitted to any authority, the federal agency or at the local level? And right now, the types of agreements codified, the task force model, the jail enforcement model, or the warrant service model, they vary wildly in the kinds of oversight and data reporting requirements that are needed to be in compliance with the agreement. But they note that of the two in this study examined, at least, the jail enforcement model gives more expansive authorities with less oversight. And so I suspect, although Keith, you might know the answer to this, that we might see that same finding with the task force model as well, that there are these sort of expansive authorities with minimal oversight, or at least minimal reporting requirements, right? What kind, how many people are being affected, how many people are being sort of put under carceral control of some way. So all of this is to say that often the rhetoric we hear to support these is the argument that it makes our communities safer, and the data from research just don't bear that out. All right, next slide.
Great. Yeah, so I'm going to jump in with a little bit of follow-up on what Amy was saying there. There are a number of key issues that are posed by 287G agreements that have been observed across the country in the areas where they exist. Now, I generally try not to frame issues around immigration enforcement in exclusively economic terms because they don't center the harm that immigrant communities face. But I do think that one of the more persuasive ways to convince local governments not to enter into 287G agreements is because of their economic impact. Under the 287G statute itself, local law enforcement agencies and local authorities take on federal enforcement functions at their own expense. That's what the law says in plain language. Um, and so it means that those are resources that are not actually being placed in local communities that might need them. Um, so, under the terms of the standard memorandum of agreement for, any one of the models of 287G agreement that we're talking about here, the participating police department is responsible for all of the salaries and the benefits, including overtime, for officers that are designated under the agreement, and they have to pay travel and housing and different things like that. And so there actually have been different law enforcement agencies in the past that have backed out of 287G agreements just because they're too expensive. In 2017, the sheriff of Harris County, Texas, which is the county that contains Houston, terminated the agreement that had been in place for a couple of years because of an estimated $675,000 in annual costs just associated with the agreement itself. And similarly, the year after that, in 2018, Prince William County, Virginia, had initially planned to divert about $800,000 in what they called the rainy day funds to cover the cost of its 287G program. But then they projected costs of ultimately like almost $11 million over a 5-year period for these programs. There have been some attempts in the past year to bring in, have federal funding compensate agencies for their time on these. But in practice, we haven't seen that actually taking place that much. There was a memo that was circulated last October that did say that the federal government was going to try to incentivize these agreements and pay for more time. But based on, what our sister affiliates at other ACLU affiliates across the country have seen, this hasn't really happened in practice. Like there have been, I think, grants that maybe will pay for like one additional police car, but not really meaningful monetary contributions. And so, I think the costs are an important way of framing them for local governments. But I think equally, if not more important, 287G agreements erode the trust that exists between local law enforcement agencies and immigrant communities. And that ultimately, I think, going to the point that Amy was making on the previous slide, has the effect of undermining public safety. When immigrant communities are concerned that the police might turn them over to immigration officials, it means that immigrant communities are less likely to want to report crime because they just don't feel safe doing it. And so, that could hamper victims or witnesses of crimes from coming forward and making a report or seeking redress through our legal system. And then finally, research has confirmed that the 287G agreements have opened the door to insidious racial profiling and other civil rights violations in many cases. And not only is this type of racial discrimination reprehensible in its own right, but it also can expose local governments to liability legally. And so they can be held accountable in civil lawsuits, for instance, for monetary damages when they violate people's civil rights. It's a few years old now, but there's a link in the on the slides, which you'll receive after this, to a report that ACLU, our national organization, put out in 2022. And this report found that 65% of the sheriff's offices nationwide that had 287G agreements have a demonstrated pattern of racial profiling or excessive force, and that about 75% of the agencies that had 287G agreements across the U.S. operated detention facilities, like local jails, county jails, that had track records of serious inhumane conditions. And so this sort of goes to the oversight piece that Amy was discussing as well. In general, there's also been an attack nationwide on oversight to ICE detention, and the oversight is even less in, at least from the federal officials, at shorter term detention facilities, which is often how these county jails might be used under 287G agreements. So next slide.
Actually,
sorry.
can I jump in here real quickly? If we think about the cost of these agreements, which you touched on, and there's all sorts of costs. Another cost is the damage it does to our labor force and the economy of our regions, right? So, for example, the population in Philadelphia has the U.S.-born population of Philadelphia has been declining, but the foreign-born population is increasing, and so between 2000 or since 2000. Foreign-born populations have accounted for nearly 75% of the growth in the region's labor force, right? And so currently, immigrants constitute 1 in 5 residents in Philadelphia, and again, as the U.S.-born population is declining, this population is not only sustaining our population, which has all sorts of effects through census and federal resource allocation. But they're also a key driver of the economy, right, of the region. So in addition to these agreements costing money in terms of resource drains, they're also harming the very populations that are the economic drivers of our regions and our state.
Yeah, I think that's an excellent point. I see a question about how the agreements are solicited, so maybe I'll go into that a little bit before moving on to the next point. I guess so. The question is about who and how are the agreements solicited? Did they send out a mass mailing to whom it may concern? And on the local side, whom among local leaders are responsible for entering into or adopting agreements? Chief of police, sheriffs, or an elected official? That second part actually is a lot of what we're going to be covering in the next few minutes, so I'll get to that separately. But about how the agreements are solicited, I mean, we've seen a really major push for outreach by the federal government to encourage local law enforcement agencies to enter into 287G agreements. Um, Even prior to the Trump administration starting last year, I think like when the Biden administration was in its lame duck period, we actually got through open records requests like a number of solicitations, direct emails from ICE to local law enforcement agencies asking if they wanted to enter into 287Gs. So there has been a push that even predates the Trump administration taking office. But even more so than that, on the first day of the Trump administration, he issued an executive order that required ICE to, in its framing, it's like kind of awkward wording, but it required ICE to authorize state and local officials to enforce immigration enforcement to the maximum extent permitted by law. And that's part of the executive order that's protecting the American people against invasion, really crassly termed. But so there has been a push that's been coming both from like the rhetoric of the current administration, direct outreach, and these executive orders that try to increase the number of agencies that are part of the immigration enforcement apparatus. Um, and we also have seen, and we've heard this from a number of local law enforcement agencies who have entered into 287G agreements, that the federal government has framed it in some ways as like a training opportunity for them, and a way to get some federal training that they wouldn't otherwise have access to. We did try requesting the training materials for 287G agreements under the Freedom of Information Act, but we haven't gotten a response from ICE yet, so we don't really know what actual training benefit there is. And then, like I was saying, there has been an attempt to add financial incentives to 287G agreements, but the announcement for ICE that ICE made about those has been they made the announcement back in October, and we really have not heard of any meaningful federal reimbursements or federal payments to local law enforcement agencies. And I guess I'm going to go back to the slides here, and then we can jump into some of the other questions that we have here. But there, so the ACLU of Pennsylvania has been very concerned about the proliferation of 287G agreements in Pennsylvania for the reasons that we were just discussing. And so we've engaged in several different efforts to challenge them under state law. We have two challenges currently to sheriff's authority to enter into 287G agreements. Those are Make the Road v. Heron in Bucks County, and then CASA v. Stimalang in Juniata County. But then we also sent a letter last summer to the Pennsylvania Constables Association. Um, I think one of the reasons why the numbers in Pennsylvania seem so high, going from 0 to 60 in less than a year, is because ICE has been conducting outreach to sort of unlikely actors. Um, in Pennsylvania, constables occupy kind of a strange place in the law enforcement scheme. Um, there's pretty good case law that they're actually independent contractors rather than official government entities, and they also have like really limited arrest powers. And so we sent a letter to the Constables Association saying that constables can't undertake pretty much any of the duties that they would be required to do under the 287G agreement. It's essentially like having a private citizen deputized by ICE, which is problematic for so many reasons. And we did, as a result of that letter and some of our outreach at that point, see a few constables back out of their 287G agreements. But it's also a situation that we're monitoring closely. We haven't heard of like massive cooperation, but even though there are a lot of constables that have 287G agreements, we haven't heard of it as a major problem yet that constables are actually trying to effectuate ICE arrests. We've been hearing it more at the, sheriff level in county law enforcement or townships as well. So the both of our cases, Make the Road v. Herod and Casa v. Stimalang, sort of focus on a couple of questions. So first, what procedures must be followed to enter into a cooperative agreement with ICE under Pennsylvania law? And then also, more related to the constable question, what authority do different law enforcement agencies actually have to undertake the duties of a 287G? Sheriffs clearly do have arrest power, and they can serve warrants. So can police, but constables, like they only can if they're either in active pursuit or they witness a crime taking place in front of them. So these are some interesting questions to definitely keep in mind as we go throughout this program. Next slide. So the first piece of litigation that we brought in Pennsylvania was the case Make the Road v. Herron, which is a case we brought against Bucks County Sheriff Fred Herron. And so Fred Herron, who was previously the Bucks County Sheriff, unilaterally entered into a 287G agreement with ICE under the task force model, so the most expansive model. And when he did this, he didn't ask or even inform the county commissioners about this agreement. So they only found out quite a bit later. And the commissioners disapproved of the agreement and ultimately adopted a resolution disavowing Sheriff Herron's entry into the 287G. But unfortunately, that didn't stop Sheriff Herron. He said that he was just going to continue to go ahead with the 287G and get his officers trained. Ultimately, he sought to have himself and 15 other sheriff's deputies trained by ICE and then authorized to conduct immigration enforcement. And the county was, definitely upset about this. They in their resolution, they said that they were the sole contracting authority on behalf of the county, that none of the costs associated with the 287G had been budgeted, things like that. And so, and then at the same time as this was all taking place, and Sheriff Herron was saying that he and his deputies were going to be adding immigration enforcement to their long list of duties as sheriffs, there was reporting that there was a backlog of several thousand warrants that actually are within the sheriff's regular purview. So, there really are serious questions here about how resources should be allocated for a county official. And so let's go to the next slide. We developed a legal theory in this case, and it's important to note this case was not just ACLU Pennsylvania. We brought it alongside our good friends with the Community Justice Project. And they also are our co-counsel on Casa v. Stimalang, and also were our partners in drafting the letter to the sheriffs or to the Constables Association. So it's a team effort. But we developed this theory that under the Pennsylvania Intergovernmental Cooperation Act, there's clear language that only the County Board of Commissioners has the power to enter into contracts with the federal government. And there also are a set of procedures that are laid out for how these agreements can be approved, even beyond a local county commissioner or a county commissioner vote. There needs to be an ordinance passed or a resolution passed, and then it needs to be submitted to the Pennsylvania Local Government Commission. And then similarly, under the Pennsylvania Constitution, Article 9, Section 5, local agencies can only cooperate or agree in the exercise of any function, power, or responsibility with the federal government by an act of the local governing body. Sheriffs are not part of the local governing body. It's the county commissioners who have that power. And so in Bucks County, that means that under both the Pennsylvania Intergovernmental Cooperation Act and the Pennsylvania Constitution, this decision needs to actually be authorized and approved by the county commissioners. And why this poses a problem is that under the 287G statute itself, 287G agreements are only valid, quote, to the extent consistent with state or local law. So a 287G agreement with a sheriff who has not followed the procedures of state law or the state constitution can't be valid under the 287G statute. So we went into this with the argument that Sheriff Herron's entry into a 287G agreement was plainly illegal. And we, ultimately thought that we had a very straightforward case under these two legal authorities that are cited on the slide. Next slide. Unfortunately, in litigation, nothing is ever quite as straightforward as it seems, and this case took a number of turns. So, I mean, first, the sheriff tried to remove this case to federal court, saying that it was a federal question about whether he could enter into a 287G agreement. We won at that point and got the case sent back to state court because it's like pretty unquestionably a question of state law. And then once we were back in state court, we moved for a preliminary injunction, which essentially would mean that the sheriff would not be able to go forward with his 287G agreement until the merits of the case had been decided. Unfortunately, we lost at the preliminary injunction this past fall, and it was mostly for fairly technical reasons. The judge that we drew found that we lacked standing. We'd brought standing as a legal doctrine about who actually can show that they have harm by a certain action and that they're entitled to bring a lawsuit under it. As one example, we had a number of different types of plaintiffs. We had a couple of organizations, including so Make the Road Pennsylvania is a membership organization that does a lot of advocacy in Latino communities in Pennsylvania. They're part of a broader multi-state organization as well. And then we brought it on behalf also of a congregation whose members also feared harm, and then a few other types of plaintiffs. But essentially, we lost at the preliminary injunction stage on standing because the judge found that the harms that we were alleging were not immediate or substantial. They were instead speculative because the 287G agreement was not fully operational at the time we brought the litigation. And so essentially it's saying, okay, wait till there's real harm. We disagree with this interpretation of Pennsylvania law on standing, and we're appealing it. Another interesting, though, piece of complicating factor here is that the judge at the trial court level tried to distinguish between what he called an enforceable contract and what he called a memorandum of understanding, and argued that a memorandum of understanding doesn't have any legal obligations that flow from it, whereas a contract actually does. But there's no language about this distinction in the Pennsylvania Intergovernmental Agreement Act. There's no case law really on this subject at all. There isn't a material difference in terms of even looking at the Pennsylvania Intergovernmental Agreement Act's name, it doesn't say the Pennsylvania Intergovernmental Contract Act. It's an agreement, and a memorandum of understanding, just in plain language, is also an agreement. And so we're currently appealing this case to the Court of Common Pleas and are hoping to have it overruled, have this decision overruled so that we can finally overturn the Bucks County 287G agreement. Let's go to the next slide. In the meantime, though, democracy worked even as we faced a legal setback here. And so the people of Bucks County ultimately ousted Sheriff Fred Herron in favor of Danny Seisler. And Danny Seisler actually explicitly ran on a platform that opposed the 287G agreement and said that he would withdraw from it as soon as he took office. But even before he took office, because of the negative publicity, I think that Fred Herron experienced here and the community outrage, Fred Herron announced that he would not go forward with the agreement during his lame duck period. At this point, we're appealing it to the Commonwealth Court, like I said, but Sheriff Herron is trying to argue that the challenge is now moot because he's out of office. Both we and then Bucks County, or the commissioners, um, believe that this argument is not moot, and so we're going to be fighting that in the coming months. And one of the reasons it's not moot, just in case anyone's curious about legal nerdiness, is that there were some parties that intervened in this matter. So the Pennsylvania Sheriff's Association intervened in support of Fred Herron, and so did a couple of sheriffs from other counties that were not involved in Bucks County at all. And so even if the decision is moot as to Fred Herron, which it may or may not be, there still is live controversy between parties that are actual parties to the case. So we think that this appeal should be able to go forward. Next slide. But in the event that it is found to be moot, and we don't get a higher court ruling on the legality of 287Gs in Pennsylvania, or the authority under which sheriffs in Pennsylvania can enter into 287Gs, we filed a similar challenge on a similar theory in Juniata County. And in this case, we also named the county as an involuntary plaintiff. There's a similar posture where the county commissioners didn't agree with the 287G agreement, and but they also didn't pass a resolution like they did in Bucks County. But we essentially said, you disagree with this, you're going to be pulled in as a plaintiff, and we're both going to be now the parties challenging the sheriff in this. And so they've actually really taken this in stride and are making really forceful arguments that the sheriff didn't follow the proper procedures. And so in one of their briefs, they included this following language that if the court holds that the sheriff can enter into a 287G agreement without the county's approval, the court is then holding that the county sheriff can raise taxes. That decision would mean that an elected official can spend money for which there would be no checks and balances. And so we think that they're raising really great points here, and it's going to be interesting to see how this pans out. This case is still in fairly early stages. We're still submitting our early briefing, but at some point this spring, we likely will have some hearings on this case, and we'll try to keep our followers updated on this. Let's see. I think we can pass it back to Amy right now for some more broader principles about 287G agreements and state authority.
Great. All right. So thank you for all of that, Keith. I also want to flag there's a question in the chat that seems to be truncated. I saw the beginning of it and now I'm seeing the end. I think it has something to do a little bit with what you were referring to earlier, Keith, about tying federal funding, sort of incentivizing federal funding or not. So if you want to sort of suss that out while I'm going through this and either answer in the chat or do you want to take it now?
I can just take it briefly now.
Right.
Yeah, I mean, I think what this question is sort of relating to is that around the same time as the Trump administration's DHS posted what they called their list of sanctuary jurisdictions, they were sort of threatening different consequences. They're saying that they'd prioritize, they would, prioritize federal funding to jurisdictions that didn't have welcoming policies. And so there's, sort of a coercion there. We haven't really tested theories under preference being given to a certain type of action being taken, but the law, like I sort of mentioned, is clear on the federal government not being able to coerce and withhold funding. So, I mean, this is a slightly more nuanced issue. It's one where I don't know that there's a whole lot of legal authority, and it's a question I haven't, fully researched or briefed yet. I know that there is some apprehension around it, but I think, on the other hand, the fact that the funding that already has been promised has not really materialized in 5 months or so is instructive that there's a lot of words being thrown around about like what might happen, but not a lot of actual actions behind it yet. If that answers it.
Yeah, I think so. Thank you. All right. So all of what Keith has been sort of hinting at is these sheriffs doing stuff, right, without proper authority, and what does proper authority look like? And so I wanted to sort of frame out the legal framework in Pennsylvania around what Pennsylvania law says. In this slide, I use the phrase home rule charter. I think that the thing that's important to note is that in the Constitution of the United States, any level of government below the state is not mentioned, right? So there's no constitutional authority held by counties or cities other than the authorities granted by the state. And so there are home rule charters. There's a whole home rule charter movement in the United States where cities tried to get authority, their own authority, to have their own executive branch, their own legislative branch, their own judicial branch. Some counties have this. In Pennsylvania, the home rule charter counties are Philadelphia, Allegheny, and a few others. Interestingly, Philadelphia is both a county and a city. It's one of only 3 coterminous county-city jurisdictions in the United States. So they have home rule charter. Allegheny County has home rule charter. There's a handful of others, but the vast majority of counties in Pennsylvania are not home rule counties, which means that they do not have some of the authorities, like having a separate executive branch from the legislative branch, from the judicial branch. So what that means is that counties without home rule charters, again, which are most counties in Pennsylvania, have what we call a commission form of government. And the county commissioners then are both the legislative branch and the executive branch. They both make the laws and then are responsible for executing the laws. They control the budget. They set the policy, so they both approve programs, but then have to fund the programs, right? They're the only body empowered to enter into binding agreements on behalf of the county, encompassing both of these powers. So they make laws, they set policies, they oversee departments and implement policies. So that's the legislative and the executive. Typically, this is a 3-commission form of government. And again, it's the most common structure. The exceptions to these rules are the home rule counties, like I said. So they'll have a county council or a board of supervisors, which is the legislative branch. And then they'll have a county executive or a mayor as the executive branch. So in the cases that we're hearing about here, these are both commission forms of government, which means that the county commissioners control both the legislative and the executive branch. Now, the sheriff's role in the in the judicial branch in these commission forms of government is a little tricky, but it is clear that the sheriff is not a policymaker, so is not the legislative branch, and is not the executive branch, right? So that the decision to enter into an agreement that would expend resources or obligate the county in any way clearly under these authorities would rest with the legislative branch. And then the ability to execute that agreement, right? Execute the law would be the ability of the county commissioners. The sheriff doesn't fall into any of those roles. So the sheriff's not a policymaker. They are obligated to comply with the law when it requires a commissioner's approval. They do carry out orders of the courts and ensure public safety, but they don't have the authority to bind a county to legal agreements or external partnerships. And Keith, I think that point that Juliana's making about if that's the case, then can sheriffs, I don't know, change marriage laws? Can the sheriffs, pass tax bills? So I think that that's a really interesting argument because clearly that he answers no, because the sheriff is not a legislative actor, nor is the sheriff an executor of these pieces of legislation. So what this speaks to is that there is a clear principle of separation of powers at these local levels that we tend to not think about, right? We tend to think about separation of power at the federal level. Can you go to the next slide, please? So remember, back in your civics class, the number one concern that the framers of the Constitution had was tyranny, right? They were concerned about a tyrannical form of government that consolidated power, and they built systems to check that power. Madison in Federalist 1, this is a quote, in Federalist 51, said, quote, "In framing government, which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and then in the next place, oblige it to control itself, right? So the trick is, how do we check power? And they did this in two ways, right? They fractured it vertically with federalism, right? So we have the federal government and we have the state government, and states have the authority to delegate authority to lower levels of government. So they fractured power this way, but they also fractured power among the institutions, the legislative, executive, and judicial branches. And we see that fracturing of power operating at all three levels of government, right? And so it is an extraordinary check on the consolidation of power. While we're thinking about immigration enforcement right now, right? Another way to think about this is we tend to think about presidential elections as being one election. And sometimes people say, well, it's actually 50 elections. But really, it's actually over 3,000 elections, because each county runs their own election in the United States. And so in order for people to be elected to the highest office in the land, every county has to agree to put that person on the ballot, right? And so there's all sorts of laws and mechanisms to ensure that happens, but it's a reminder that power is really fractured, both vertically and horizontally across these levels of government. And this is really important. Separation of power prevents government overreach, and it protects the democratic process. So policy decisions, especially those that affect civil liberties and local policing, must be made transparently and with public accountability. And we see that with our elected commissioners representing the will of the people. They have to approve major initiatives like ICE cooperations, right? That is that accountability and safeguarding through the democratic process. It reinforces, again, that accountability and legal compliance. So unauthorized agreements could expose the county to legal and financial liability, as we've seen these lawsuits, and financial cost. It violates residents' rights and undermines the trust in law, and it circumvents these checks and balances, right? So it violates this principle of accountability and compliance. And as Keith has touched on, community trust and public safety are also at stake. So vulnerable communities, immigrant communities, are disproportionately affected by ICE cooperation. These are communities that are already underrepresented in our democratic institutions. So it's worth noting that optically or politically, it is often easiest to target demographics or populations that are the least powerful, right? I used to remind my students all the time, they get really frustrated about higher education funding or student loan policy. And I said, well, we're sitting in an American politics class. Who votes? And it's not them. And so, if you're not holding your elected officials accountable, it's hard. It's hard to make them pay attention to you. And so, and the reverse can be, the reverse is also the case. So it's easier for our elected officials or our agencies in some respects to enact agreements that target populations that are not as active or engaged. And so in that respect, it's really important for nonpartisan organizations like ours to be talking about this and learning about this, because we have to be mindful of where political power sits. So these communities are already underrepresented. When decisions are made unilaterally and without oversight, it sends a message that some voices matter more than others, some residents matter more than others, and that damages the fabric of our neighborhoods, of our communities, and of democracy. And effective public safety requires that trust between the community and law enforcement. And as we saw in the studies, despite the fact that the rhetoric around this is often that it promotes public safety, it in fact doesn't, right? It actually erodes that trust and can therefore actually increase harm in communities despite the intention. And then the broader implications, and I think that there's some really interesting questions around the role of constables here, the broader implications for local governance. These just highlight the dangers of blurring boundaries between branches of government. Again, the principle of separation of powers is there on purpose. It can be frustrating. It can slow policymaking and decision making down, but it is there. It is designed to promote accountability, promote transparency, and promote citizen input and access into the decision-making process. And so when those when the separation of powers principle isn't followed, when the law isn't followed and law enforcement enters into agreements against what the letter of the law states, then our accountability as citizens is diminished. Adherence to legal compliance goes down, right? All of these things that are essential to good governance is weakened. I think that's it for me. Do you want to go to the next slide? All right, so
Great,
what
yeah.
can be done?
Yeah. So, yeah, I want to talk a little bit about what, can be done, what we can all do to try to stop 287G agreements, and also more broadly disentangle local law enforcement from immigration enforcement. So first, I mean, one way that this type of change can happen is through presidential legal decisions. We're hoping that through our current litigation, either in Make the Road v. Heron or Casa v. Stimalang, we'll get a statewide ruling on what process a sheriff needs to go through in order to properly ratify an agreement and under which circumstances a sheriff cannot. But this is not necessarily a panacea. It's not going to solve everything. There are even a good decision in this area realistically will be limited to sheriffs who are unilaterally entering into 287G agreements in places where where the county commissioners don't want to be a part of it, right? So it's a very limited set of facts. And there are some places where even if the sheriff doesn't follow the proper procedure, as soon as the county commissioners as soon as litigation like this is filed, the county commissioners could just go ahead after the fact and ratify a 287G agreement. And so, while we are hopeful for the prospects of this litigation, it isn't a cure-all. It's not going to fully, challenge 287, or it's not going to lead to an end of all 287G agreements in Pennsylvania. But we are, actively looking at other theories. Like I mentioned with the constables, like we do have some good legal theories that are already in our pockets that we've explained to the Constables Association, and are ready to deploy as needed. But ultimately there are some open questions here about, what powers does the Pennsylvania Constitution, like, does the same reasoning that we've applied in these two cases as to local sheriffs apply to local police departments, and what's the extent of that cooperation? And these are sort of unanswered questions. We're hoping to continue to build out good case law that will challenge 287Gs in Pennsylvania and hopefully lead to broader, blocking of them statewide. But ultimately, a lot of the work probably is, it's important to do more on a legislative side rather than litigation. And so, like I mentioned earlier, there have been a lot of states that have passed. There's been a trend of states moving toward banning 287G agreements statewide. Maryland just did, I believe, just as recently as 2 weeks ago. And Delaware did just last fall. So there is a movement, and we're not there yet in Pennsylvania with our state legislators, but that's not to say that sustained advocacy couldn't eventually move our legislature to do an outright ban. And that would be, a really great goal for, us to all push for. But short of that, we can all be active where we live. And so one of the asks I think that you're going to hear from Alan after this program is about advocating for a welcoming ordinance in your county or township that essentially would disentangle law enforcement from immigration enforcement at the local level. Some places already have this. Some places, really are resisting, but sustained advocacy can bring about real change. And so I just want to talk briefly about a few of the important things that could be included in a welcoming resolution, both in the context of 287G agreements and then also beyond. Like I mentioned, there are a lot of different ways that local authorities can be entangled in immigration enforcement. So a few components that are important to try to include as you go through this process is to have part of the legislation say that no contracts are signed with federal agents carrying out immigration enforcement, including in the context of 287G agreements. Also, that local authorities are prohibited from holding a person for immigration enforcement through ICE detainers unless there's a judicial warrant present. And then also another way that this entanglement occurs is through data sharing. And so, legislation that prohibits collecting information about immigration status unless otherwise required, and then also that bars general sharing of information about local people unless there's a judicial warrant, including like local databases that different counties or localities might maintain. And then, as you push for these, I mean, some places it's just going to be there may not be the legislative desire to implement it as a resolution or an ordinance, but to the best extent possible, those are the most durable way of implementing this change. And we have been seeing a trend of a number of different towns and cities across Pennsylvania uh, adopting these types of ordinances through sustained local advocacy. Um, you know, uh, and they're not all like the usual suspects. And so, I mean, I know recently Reading passed one just a few months ago. There are a number of counties that have adopted them at the county level. But so basically, though, it's something where, if you don't want ice to be entangled in your part of the woods, it's important to get involved and do this. And so, yeah, I think those are a few, key ways that we can work to stop 287Gs. A lot of the organizing around welcoming ordinances and a lot of the technical advice has been coming from the Pennsylvania Immigration Coalition. They do really great work and have mobilized campaigns in various parts of Pennsylvania. They do take both individual members and organizational members. So, if you're interested, you could reach out to them for more advice. But yeah, it's definitely been part of a trend and important local mobilization that has led to the disentanglement of local resources from federal immigration enforcement.
Thank you. Before we get to the last slide, the concluding slide that I'll just wrap things up. Keith, if folks advocate for a local welcoming ordinance or a statewide ban, whatever flavor of advocacy they want to engage in, is it necessary to how specific does the advocacy need to be? Do we need to be specifying the models of the agreements that can be used? Like we're specifying all three models aren't allowed, or you know what I mean? Like, is it necessary to sort of get into the weeds on how these work in that advocacy, or once they're banned, are all models of them banned?
Yeah, I mean, I think that so there's a difference between like what you can do legally and then what's going to be politically possible.
Mhm.
Obviously, I would advocate for the broadest coverage possible to have this disentanglement happen. A lot of the language that I've seen in like welcoming ordinances around 287Gs explicitly ban just all agreements that are authorized by Section 287G of the Immigration and Nationality Act,
Yeah.
which would cover all three models. I haven't really seen it done in anywhere actually that like distinguishes between them. It definitely is possible, but I would say, try to go for the maximum coverage possible, and then if the political reality comes and doesn't, and that doesn't seem feasible, then maybe, consider what's possible versus what's ideal.
Yeah. Thank you. That's good advice. And actually, that takes us to the conclusion. So, next slide. Right. So, all of this is pointing at encouraging folks to tap into this issue, how it feels relevant to you, right? It could be about local authority and local autonomy, could be about civil rights and immigrants' rights. It could be about federal interference, right, which we're seeing across all kinds of domains. So advocating for these local welcoming ordinances or a statewide ban is both a test of our local democracy and our constitutional structure, but it's also an opportunity for us to continue exercising our civic muscles, right? We don't wake up sort of being super voters or super citizens. We find things that really matter to us. Nobody wakes up one day and decides that they're going to be an activist, right? They wake up and they realize that there's an issue really affecting them that they really care about. and they figure out how to plug into that issue. So the sort of broad purpose of this presentation is to remember that even at the county level, these separation of powers matter. Holding authorities accountable matters, right? No one official or agency should be allowed to overstep their authority regardless of the issue, right? And especially on high stakes issues like immigration enforcement or voting rights, right? We're seeing all sorts of uh, push back against expansion of voting rights. Citizens have mechanisms to hold our elected officials accountable. And of course, if all else fails, we can vote folks out of office, as we saw in Bucks County. The benefit of the structure of our government, there's pros and cons. The way our government is structured, the number of elections we have to be engaged in, it takes time, right? It takes educating ourselves. It takes time coming to these meetings. It takes time. But the benefit is that we have so much access to our elected officials and we have so many opportunities to hold them accountable. That really, we're hoping with this information that if some part of this issue moves you, you now have the tools or at least a better understanding of how to plug into this issue and where to advocate. And as Keith mentioned, I know that the League of Women Voters of Greater Pittsburgh will follow up with folks with information, and this recording will be available to anyone who registered, and we can share out the slides as a resource. But really the point is to find that issue. If it's an issue in this, like I said, local authority, separation of powers, federal interference, immigration rights, all of those issues are packed into this 287G agreement topic, right? So if any of those speak to you, hopefully you found this helpful and interesting. We have about 10 minutes left for any kinds of questions. I don't know if Keith, if you have anything you want to say as part of a wrap up?
Well, so I just typed in an answer to one of the questions about how, is there any evidence that or concern that a welcoming ordinance will attract ICE activity? Um, at least from what I've seen across Pennsylvania, I haven't seen, most or any of the local townships that or counties that have passed welcoming ordinances being directly targeted, at least yet. It definitely is a risk. There is a lot of rhetoric out there about how, people are going to target the Trump administration or the DHS or ICE are going to target what they call sanctuary jurisdictions. But realistically, they're not everywhere at once. And it hasn't really been borne out even in the places that have passed welcoming ordinances very recently. I think it's also important to remember that if and when ICE does target a place, it's better to have good policies in place that can minimize the harm done. And so a welcoming ordinance can do that and lay groundwork for, ICE not being able to making ICE's job more difficult because there isn't going to be local support or buy-in. So
I think that's right.
yeah.
And the other thing that I'll add, one of the things that I think is really has frayed over this really sort of several decades of polarization and divisive politics is sort of a sense of shared fate in our communities and a shared goal and finding our neighbors who are like-minded. It's become harder to do that, and the act of organizing, right? The act of finding people who want to work on this issue, or the act of finding organizations, whether it be, what Keith has mentioned, or the ACLU or the League, right? That also prepares us. So if this sort of activity does attract attention, in addition to having good policy, we also now have a network, right, of people who will help, right, and will show up and will continue to advocate for civil rights and for just treatment and for all of the things that we want in a democratic society. And so not only is the end goal great because it can help protect us, but also the process of getting there helps us build that community that I think lots of people are missing.
Yeah. So I also just answered in text about whether there's a model ordinance. I believe so. The Pennsylvania Immigration Coalition does have a model ordinance, and I believe it's going to be shared with you all following this presentation in an email from Alan. and it does contain pretty much all of the elements that I was, mentioning earlier. Um, I see a question about,
Yeah.
the masking of federal agents and how local law enforcement can tell that whether or not someone is legitimately a federal agent. I mean, I think the point is that one of the harms that's caused by federal agents masking themselves more is creating this blurriness, and it just creates an atmosphere where more abuses can take place. Um, I mean, so yes, like I do agree that local law enforcement, to the extent possible, should make sure that any masked officers are actually law enforcement. Um, but that's, not something that's very easy to address, via absent federal legislation. There have been a number of different
Mhm.
efforts in local, in different localities across the U.S. to have anti-masking legislation. I think it's an open question whether those will withstand legal scrutiny. But I think also they've been a pretty good mobilizing cause because ultimately, it is a very vivid image seeing masked federal agents grabbing people and trying to find a sort of what seems like a common sense way to stop them. And that also can be a vehicle for getting in other changes, that might also be included in a welcoming policy. But I would say if you do that and do pursue it that way, make sure that the ordinance that you have has a severability clause in case the masking ordinance could get struck down.
Goes down. Yeah, and this is also a point that Keith and I were talking about earlier, that sometimes the political strategy or the rhetorical strategy or the organizing strategy to get the changes that you want might take one shape, and ultimately the policy outcome might take a different shape, right? Because of litigation or legal decisions or what's possible to get through a three-person commission or the Pennsylvania state legislature. So it can look very different, but there are benefits in the organizing, and then there's benefits in the policy making. They don't. They sometimes have different benefits, but they are both beneficial. I guess one part of this question, though, is built not just around masking requirements, but um, just identification, like requiring certain, so even if they're not wearing a mask or covering their face, are they required to show some sort of ID that when you're underage, your ID is the wrong way, so they can quickly tell that you're not right? I mean, is there some way to require a type of ID that would quickly identify them? Um, and would that sort of requirement hold up in court?
Yeah, I mean, I think there's a lot of different facets to this issue. I think ultimately, the most strong venue for bringing anti-masking legislation would be coming from the federal government itself.
Mhm.
They're the ones who have the ultimate authority over federal agents, and so they're the ones who would be most able to change their actions through legislation or through even just through policy at DHS. Even though I don't give that much likelihood of success at this point. But I mean, I think also if one were to try to pursue a local mask ban or statewide mask ban, one of the ways that it would be the strongest legally speaking is if it applied to all law enforcement, isn't like clearly singling out federal immigration enforcement.
That's right.
And I think that's like a model that we're seeing in several places. It needs to be carefully thought through, carefully drafted, and wordsmithed, and have certain exceptions to for undercover people, undercover agents, or religious facial coverings or facial coverings for health conditions or health prevention. But I think there are ways that it can be experimented with, but it's one that you want to be careful with.
Yeah, and this is a really important component of understanding how power is fractured um, between the federal, state, and local authorities, right? So, in lots of ways, policing is a state, is sort of controlled at the state, broadly speaking. So, both defining criminal acts and defining punishments for those acts. That includes morality codes. So, the liquor laws are different in California than they are in Pennsylvania. That's all at the state level. But this question about federal agents, right, obviously wouldn't fall under the state authority. And so, as Keith said, understanding who and what you're targeting, and then understanding which level of government has authority over that entity or that body or that agency, whatever it is you're thinking about, is a really important part of this. And then making sure that, any sort of advocacy around that is very clear in what you're asking. We have a couple more minutes. I actually think I see you're typing an answer here, Keith, but I think this is a timely question. Can we include limitations on ice near polling stations? There are already laws on the books that prevent federal agents from being, do you know the distance?
I
200
think it's
feet?
100 feet, but I'm not
100
part of our
feet?
voting rights team, so we have
Yeah,
other
it's
experts on our side that know that stuff.
I should have that off the top of my head, but within 100 feet of polling places. So that law is already in existence. One of the things that organizations like the League are thinking about is what happens if they're 101 feet away from the polling place, right? So they're complying with federal law, but they have a chilling effect. And again, this gets at the legality of something versus the sort of political strategy behind something. And so it's really important to know what the law is, which says that federal agents are not supposed to be within a certain number of feet of a polling place. But if you're that number of feet plus one, right, how do we make sure that people feel safe and comfortable to show up at their polling places? And there's lots of organizations getting involved in doing that work and recruiting folks to be poll observers and election protection observers. And we will be hosting information sessions about that as we approach elections. So, Dawn, the short answer is they exist. The longer answer is it's complicated, which seems to be the answer for everything these days. I think we're about at time. I don't see any other final questions. Alan, should we pass it off to you to take us out?
Sure. Thank you very much, Amy and Keith, for sharing such very important and timely information. Now that we are full of great information, we hope you, the people listening, will go to your town council if it has a 287G agreement and ask them to rescind it. As Keith mentioned, those towns are Stowe, Springdale, and Monroeville, 6th Ward in Allegheny County. We also hope you will ask your town council to pass a resolution to not cooperate with ICE and CBP, including not signing a 287G agreement. I'll be sending all of you a blind carbon copy follow-up email, and I'll ask if you would like to be put in touch with others in your town who attended this webinar and others I might know, so you can approach your town council together. So please let me know. The follow-up email will also include resources and a link to this recording of this webinar and the model ordinance. So with that, thank you all for attending. We hope you got a lot out of it, and keep up the good fight.
Yeah.
So
Thank you, everybody.
have a
Thank you
good
all.
night, everybody.
Reach out if you have any further questions.
Yeah.
Have a good night.